On June 7, 2018, the Verkhovna Rada of Ukraine adopted the law on the High Anti-Corruption Court, and already on August 2, 2018, the High Qualification Commission of Judges of Ukraine announced a competition for the position of judges of the High Anti-Corruption Court and the appeal chamber of this court. The Public Council of International Experts is called on to assist the commission in forming the new court. 5 international organizations with which Ukraine cooperates in the field of prevention and combating corruption had submitted proposals on the PCIE composition, which was approved by the Commission on November 6, 2018. The PCIE consists of Aurelijus Gutauskas, Lithuania, Flemming Denker, Denmark, Ted Zarzeczny, Canada, Mirjana Lazarova-Trajkovska, Macedonia, Lorna Harris, and Sir Anthony Hooper, Great Britain. Sir Anthony Hooper was elected the chairman of the Public Council of International Experts. For over 20 years, he has worked as a barrister in England and Wales, prosecuting and defending under criminal cases, including the ones relating to corruption. For almost a decade, Sir Hooper served as a judge of the High Court of England and Wales. He held the position of Lord Justice of Appeal, dealing with many civil and criminal cases. Sir Anthony Hooper has also advised internationally on criminal justice reforms. On February 8, 2019, Sir Anthony Hooper gave an interview to the press service of the High Qualification Commission of Judges of Ukraine.
I've had a long life, but I don't think I have ever done anything as exciting as what we have been doing here in Ukraine. This is the first time any country has ever invited a group of international experts to help in the appointment of judges. No other country has ever done this, and I'm very glad I was involved in it. Well, I think we were all in a state of not knowing. I don't think the High Qualification Commission probably really understood in what was the difficulties and problems that lay ahead, and I certainly didn't. But I saw it immediately as very exciting because no one had ever done this before in the world. To be involved in an international first is very exciting for everyone. I obviously discussed it with my wife. She was very excited about the project, like I was, and she has been with me in Kiev. She's here at the moment. She's been here nearly a week. And she came with me on December the 27th, the day that the exam results were announced. And she spent 7 or 8 days here in Kiev. I'm jealous because she has spent more time looking and wandering around Kiev than I have been able to do. And she has fallen in love with Kiev. I have no doubt at all that this has been very successful. And as I have said many times, we in the PCIE have had the fullest cooperation from the High Qualification Commission. We could not have asked for more help, more cooperation than we have had. It's been an amazing team effort. And I'm very grateful to the chairman of the High Qualification Commission, the vice chairman and the members for the way that they have cooperated with us in this exciting adventure, to use your word. They all impress me. But obviously the chairman is a very important member, and he and I have worked closely together. I have only met very few judges, and the judges that I was meeting, we were having to question. And I have not met many Ukrainian lawyers. I think it's difficult for me to give a general impression of either lawyers or judges. There are very big differences. It is amazing that these two systems of law exist almost across the globe. The common law system is used in a huge number of countries. It's coming across the world: Australia, New Zealand, Singapore, Hong Kong, through Africa, the whole of East Africa, Nigeria, Ghana, coming across to the United Kingdom, the United States, Canada, West Indies, the Caribbean. It's a very widespread system, and the civil law is very much in Europe, but also the basis of the Chinese system, of the system in China, is civil law. Perhaps one big difference is that the common law system relies on cross-examination, a belief that the truth can be discovered by giving one party the opportunity to cross-examine the other party and its witnesses. I think the second big difference is in the way that we, in the common law system, we do not have the system of appeals which exists in civil law countries. There is no right to a second appeal. And so, whereas here you have hundreds of appeal judges, in England and Wales, with a population of 60 million, we have 40 appeal judges. That's a big difference. I don't think I know of any country in the world, again, that is as transparent as Ukraine. If you just think about it, we were asking questions of serving judges, questions about their assets, their declarations, their tax affairs, and all of that was available to be watched on YouTube. In the United Kingdom, competitions are held, but the decisions are reached in private meetings, and no one is watching them on YouTube. I congratulate Ukraine. I think that, again, is a very difficult question. I hope that the work we have done with the Anti-Corruption Court will improve the level of trust in the judiciary, but it is always important to make sure that judges who do not have integrity or practical skills should not be judges. You cannot have a society which is not corrupt without an independent, impartial judiciary. There are many things that have to be done to reduce corruption, but one of the most important is a judiciary which is independent, impartial, and is not corrupt. When that day arrives, the trust in the judiciary will increase. I think, for example, in the United Kingdom, the figures are about 70–75% trust in the judiciary. I am hoping to be involved with the training of the judges in the Anti-Corruption Court. Together with the World Bank, I have developed a course for judges and prosecutors. It is called Convicting the Corrupt and Confiscating Their Assets. And it's a 4-day, very practical course, almost no lectures, just the participants having to do practical work to understand the law relating to corruption and the law relating to proceeds of crime. And I would hope to give that course to the new judges of the High Anti-Corruption Court, and also important that judges of the Cassation Criminal Court who will hear appeals also attend the course. I have given this course in many countries, and the last country I did it in was in Kazakhstan. I think the youth, the young people of Ukraine, they have many dreams. Some gave up their lives in 2014, and I hope their dreams are realized. A second very trivial thing, you all speak very fast. I think it's a beautiful city, and I hope you will do your best to preserve the beautiful buildings. I don't think I would be sorry to see some of the Soviet buildings disappear, but your 19th century architecture is very beautiful. and your churches, your monasteries, amazing. First of all, helping the new judges to understand the law relating to corruption, proceeds of crime, issues of judicial ethics. And as I understand it, there are a large number of cases waiting to be tried. We would want those cases to be tried as soon as possible, with no procedural delay. There are three key things that need to happen. You have a very good NABU, you have a prosecutor's department, but I don't know anything about it, and hopefully the new judges will do the work they have to do. To succeed, you have to have a NABU, good prosecutors, and good judges. And cases must move quickly. During the hearings before at the special joint meeting, I think there was one case where nearly 13 years had passed and the person had not yet been tried. One should be looking at, from the time of arrest to the end of the trial, certainly no more than 1 year, and hopefully much less. And that's ambitious. What it tells the people of Ukraine is that the corrupt cannot just wait for years, wasting court time. And secondly, the assets of the corrupt must be taken away. Even if a corrupt person goes to prison, if he comes out and has all his money, justice will not have been done. Those assets must be frozen and later confiscated. If the court can achieve all those things, it will succeed.